When Martin Fleming met David Michael Crawford, he could not have known what chaos this man would introduce to his life. When Martin recommended another man for the job Crawford wanted, he did not know he was painting a target on his own back. Nothing could have prepared him to be the victim of an arson that would go unsolved for a decade, but that wasn't even the most shocking part of this case. You see, Martin Fleming was the deputy city administrator for Laurel, Maryland. And despite his feelings about hiring Mr. David Crawford, the city's mayor and city council did hire him and gave him a highly respected position within the community. He became Chief David Crawford. Crawford and Fleming worked side by side serving the citizens of Laurel, Maryland, albeit in vastly different capacities. Fleming's role was focused on the administrative issues, while David Crawford served first as the deputy police chief and then was promoted to police chief. But after Crawford retired from that role, he was ready to burn bridges, so to speak, with those people that he'd encountered throughout his career and personal life that he felt had wronged him. Marty Fleming found his name on that list. Today we kick off a multi-part series of Maryland's most recent serial arsonist on Crime to Burn. Welcome to Crime to Burn, where we explore the dark city landscape where true crime intersects with arson and criminal negligence. Join us as we sift through the ashes and bring you the story of what really happened. Welcome back to Crime to Burn. I'm April, a fire protection engineer and former firefighter.
And I am a world champion, imaginary world champion.
Excellent. Please follow us on Facebook, X, and Instagram. It helps tremendously if you like, comment, and share our content, as that tells the algorithmic overlords to push our content to new people. If you enjoy what you hear, please consider giving us a 5-star review. It is the best compliment you can give to any podcast that you enjoy. And we would greatly appreciate if you would send any constructive feedback to crimetoburn@gmail.com or reach out through one of our social media platforms and give us the opportunity to address any concerns you have before leaving us a low review. I'm going to put some timestamps in the show notes for this in case you want to skip the disclaimers. Just know I'm not doing anything that should get me sued.
That's the goal.
That's the big disclaimer. I'm not accusing anyone. We have some exceptionally important disclaimers here for this case, and they are really important in this case. David Crawford was found guilty by a jury for some of the arsons that we're going to discuss in this case. However, he has not been charged or convicted with all of the arsons we're going to discuss. You see, he allegedly set fires in at least 6 counties in Maryland. When the state had to decide how to prosecute this, they started in the county where the charges would be the most serious. But there may be reasons that I'm not privy to for why he hasn't been charged in all of the fires we're going to discuss. I'm going to include information the police found that appears to possibly lead one to make a conclusion that he may be responsible for each fire, and it does appear from the court proceedings that this was the intention of the prosecution to leave one with this impression. However, only the crimes Crawford can be called guilty of would be the crimes for which he's been convicted. In one county, Crawford took an Alford plea, which I need everyone to understand is not an admission of guilt. It only acknowledges that the jurisdiction probably has enough evidence to convict, and this allows the defendant to take a plea deal without pleading guilty or admitting to any crimes. So while he did take this plea, it does not mean that Crawford has confessed to this crime. In fact, to my knowledge, he has not pled guilty to or confessed to any of the fires we're going to discuss. At the time of the trial, some of the fires had not yet been charged or litigated. However, the kind of evidence that tied Crawford to the fires for which he was convicted matches up shockingly well with the evidence of the fires for which he has not been convicted. However, I am not in any way alleging that he is guilty of any of the fires for which he has not yet been convicted. Until a court finds him guilty of those fires, he is innocent until proven otherwise, as is any accused person in the United States. And I will do my best to remember to use the words alleged and allegedly when discussing those fires for which he's not been convicted, but we're dealing with a lot of fires in this case, and I may slip up, I may forget, so please allow this to serve as notice but I am not in any way alleging he is guilty for any crime that he has been accused of, tied to, alleged to have associations with, but has not yet been found guilty by a jury of his peers. The next disclaimer, and this one's exceptionally important. Mr. Crawford's wife, Mary Crawford, is an attorney. Nothing I say in any of the episodes on this case should be construed in any way to suggest that I believe that Mary Crawford has done anything wrong, immoral, idiotic, or otherwise. She is not accused in any way by anyone of any kind of involvement, and there is zero evidence that I have uncovered or that anyone has presented that she could have or would have had any knowledge of anything we are about to discuss related to her husband. Mary Crawford chose to exercise her constitutional right to spousal privilege, which I think was the smartest thing for her to do from my standpoint on the outside looking in. I cannot know anything about her marriage, her family life, or her personality beyond the limited testimony given in court by other members of her family, and so I cannot and have not drawn any conclusions about her whatsoever, good, bad, or neutral. There are some accusations made at times about family relations in court and in the press coverage of this case, but I want to make it clear that these are not my impressions. I may at times discuss possibilities for how Mrs. Crawford or the defendant or their families may have reacted or felt, but those are nothing more than speculation and hold no value beyond enabling discussion of the reasons that things may have happened the way they allegedly happened. So to make it abundantly clear, Mary Crawford's not a co-conspirator. We have no evidence that she could have or would have had any knowledge of any of these activities, and nothing I say should be taken to mean anything different. There are some crimes that some people in Crawford's family have discussed with the press that those people allege that he may be responsible for and that are not included directly in this case. Now, because of the way that they may be associated with Crawford's personality and the way he behaves when he's angry and things like that, based on other people's opinions, I feel that they're important to bring up. However, he has not been charged with any of those crimes outside of the arsons that we're going to discuss, and I'm not suggesting that he did or had anything to do with him, but because he has family members that have openly suggested he is involved in the press, I will be going into those incidents. You will have to decide for yourself what you think. I just can't in good conscience completely omit them from this series, and as a sub-disclaimer to this disclaimer, some of those crimes involve a minor, and I'm going to do my level best to leave this child out of as much of the discussion as I can. I'm not going to be revealing their name, age, or status, or gender, because my intent is to focus on the person being accused in court and also by family in the press, and not on the victims of that crime. So, just letting everyone know up front, this child I'm going to do everything I can not to bring up the child beyond what's absolutely necessary to explain the situation. In preparing for this case, I listened to court recordings. That means that I got to hear bench discussions between the attorneys and the judge. So whenever they had a disagreement about statements made by witnesses, about evidence that's admissible or not admissible, I got to hear that as part of the public court record. However, I may be sharing some of that information with you, but know that the jury does not get to hear those bench conferences and all of that back and forth. And so there may be good portions of episodes that I share with you that were not revealed to the jury, for good reason, because they were based in solid legal precedent. Now, I'm going to be doing my best to help separate what was known to the jury from what was not known to the jury, but at times I may inadequately differentiate that kind of evidence, so I need everyone to remember the jury that made the decision to convict Crawford didn't have access or knowledge of everything we're going to be presenting in this case. Now, inclusion of that information that was deemed not suitable for presentation to the jury, once the court made a ruling to present that evidence to the jury, would have absolutely been a violation of Crawford's rights. So keep in mind, some of the information is hearsay, and hearsay is not admissible in court. Some of it involves speculation on the part of a witness as to motives or intent of the defendant. That's not allowed in court. And witnesses cannot testify to the motive, thoughts, or intent of another person. They can only testify to their personal experience and how they reacted to input from other people. So some things were omitted because the potential prejudice that they introduce against the defendant outweighs the probative value of the information. So in other words, it doesn't mean that some of the information is untrue. It just means that because it paints the defendant in such a poor light, that the evidence it's providing isn't strong enough to justify allowing that prejudice to get to the jury. Also, I want to remind everyone one last time, every defendant is always innocent until proven guilty. It is not a defendant's job to prove he is innocent. It is the prosecution's job to prove he is guilty beyond reasonable doubt. Everyone is to look at a defendant as innocent, and each witness or evidence the state presents may tip the scales toward guilt, or the evidence may be flawed or weak or disregarded by the jury as unreliable, but it's absolutely the job of the state to prove their case. It is never the job of the defendant to prove they're innocent. The defense's job is only to call into question any evidence or testimony presented in court that may introduce reasonable doubt, and where appropriate, have their witnesses directly refute events or evidence presented. So, their job is basically to just weaken the prosecution's case, and no defendant ever has to take the stand in their own defense. And there may be a myriad of valid legal reasons not to take the stand in one's defense that have nothing to do with guilt. A jury is never permitted to negatively consider a defendant or witness exercising any of their constitutional rights, especially when they exercise their right not to testify in their own defense. And keep in mind, Mary Crawford also exercised her right in this case not to testify against her spouse, and that is her constitutional right and should not be taken as a negative mark towards the defense. Alright, we're almost done with the disclaimers, so we can get to the good stuff. But I did talk to people that knew and worked with the defendant. They have all requested that I keep their statements off the record, so I cannot name their specific role in his life or share direct quotes, but I will be relaying information that they shared with me without citing specifically who it came from. I'll just be citing types of relationships. I also have people involved in this case that have agreed to talk with me in the future about the case. Maybe before the series is finished, maybe as a follow-up. There's situational challenges to some of those requests that we have to work around. And as we start this case, there is a pending appeal, which means that every witness in the case is off limits to me until the trial is concluded. So I have not spoken to any of the people that testified in the trial. Okay. I have reached out to people that have not responded to my requests for comment, and when I reference information from any source that I spoke to, keep in mind I am presenting a lot of hearsay, which is not admissible in court, and this isn't a court, so that's okay. But I am not presenting ideas that people I've spoken to have given me as my own. I am only presenting them as they have been presented to me. They are not corroborated fact, but I have vetted all of the people that I spoke to make sure that they are who they say they are, and that kind of thing.
You're kind of like a journalist.
I'm trying to be. Also, I feel like this is important to bring up. One of the counties where some of these alleged crimes occurred is Prince George's County, Maryland. I feel like it's important to let you all know that I was a volunteer firefighter in Prince George's County, Maryland. I don't recall meeting any of the people that are listed as firefighters, investigators, police officers, witnesses, or victims related to this case during my time in PG County, but I can't rule it out completely as a possibility. I present this information to you so that you may be aware of any implicit bias that I may have as a former member of PGFD. Implicit bias is unconscious bias due to prior influence. My overall experiences with PGFD were on the whole positive, and it is possible that I subconsciously view these organizations more favorably than another podcaster might.
On the whole?
Yeah, on the whole. It's possible that I view these organizations more favorably than another podcaster might that hasn't had any connection with that specific fire department. I also trained at some of the same training organizations that investigators and firefighters listed in their training as they were being qualified to serve as experts in this case. So there may also be some implicit bias there. So just want to put that out there so everyone knows.
I don't have any bias.
No.
I want you all to be aware of that.
But this is definitely in a place that was my backyard for a long time. Also, I grew up in Maryland. So you grew up in Maryland for part of the time.
Yeah, a little bit. Did a little growing up in Maryland.
It's always my intention to be completely unbiased and just present the facts of a case without inserting my own bias or emotional responses so that you can form your own opinion. When I do present my opinions, they are not to be interpreted as being of higher importance or greater relevance than the opinions presented by those directly involved in the case. When I present my own opinions, they're solely intended to allow us to have a discussion and analyze the information that we've seen for entertainment purposes. As a final point, I hope this is my final point. I've been working on this case for literally a half of a year now. I started working on this case before the Benson case, which launched back in June. I had intended for this to be our first case of the relaunch, but then I shifted when I realized just how complex this case is. And at the time that I'm writing this first episode, I am still awaiting some court documents related to an appeal. I'm also not in possession of all of the court transcripts. I opted for court recordings. A lot of people don't know this. Did you know court transcripts are a legal document?
They're illegal documents?
They're a legal document.
So what do you mean? Illegal document? Why is that?
When they produce court transcripts, they have to be reviewed and certified by the court as a fair and accurate representation of everything said in court. So because they're a legal document, they can be quite expensive. The transcripts for this case would have cost me thousands of dollars. The court recordings cost me $25 a day, which is still expensive because it was not a short trial. So I opted for court recordings, but I want to make sure everyone knows. I only got the court recordings for the actual trial, which still cost me, I think, around $300. I did not get the court recordings for all of the pretrial motions, which is where they would have argued about inclusion of witness testimony and evidence and moved for things to be excluded. I don't have that information because I can't afford it. If this upsets you, reach out to me at crimetoburn@gmail.com. I'll give you my Venmo and you can send me the money and I'll get those recordings and we'll do a follow-up. But I just can't afford to spend more than I've already spent on this case. This has been a lot. Also, I did reach out to Mr. Crawford's defense attorney.
Okay.
Yeah, his name is Mr. Bonsib. And I reached out to him through his website and I invited him to talk to me, either on or off the record, about the case. And my offer was specifically to keep our discussion focused only on court decisions, which would be the basis for the appeal that he's filing right now. Not to discuss his defense strategy, not to discuss, witness testimony or evidence or anything like that, just to discuss why he thinks the court erred in some of their decisions. But I haven't heard back from him. However, Mr. Bonsib, if you're listening, you can find me at crimetoburn@gmail.com. I'd love to talk to you.
That would actually be pretty interesting.
I think it would be really
Just
interesting.
a perspective, kind of help out.
And it feels weird to listen to so many hours of court recordings and hear people's voices for so long, because it really makes them feel a lot more human than when you just read a transcript.
Mm-hmm.
I feel like I know him. I recognize his voice now. I even recognize the defendant's voice, even though he doesn't speak very much during the trial. Anyway, I'm not surprised that I haven't heard back from him, but I am hopeful. And finally, I apologize, guys, for these long disclaimers, but when you're dealing with a case that's as sticky as this one, where there's ongoing litigation and the wife is a lawyer, there is a really strong desire to prevent anything that might get you sued. So...
If you thought $300 was expensive.
Yeah. Alright, so when I present ideas and theories made by the prosecution, just keep in mind those are not my ideas and theories. When I present defense responses, those are also not my ideas, thoughts, or theories. I'm trying to present this as a neutral party. However, to make this an interesting story to tell that's engaging, I may adopt a narrative style at times that appears to imply that I think Crawford is guilty, and I want to make it clear that a storytelling methodology is intended only to keep the narrative engaging and is not intended to sound accusatory.
And I have a disclaimer too.
Okay, what's that?
I know kind of about what the case is about a little bit, but I don't know any details, and I've on purpose not looked at it so that I can give... You asked me to have a genuine reaction, so I haven't looked into it. All my opinions are mine, and if I come up with the wrong thing at first... That's my right to do that. That's my right of expression. That's my freedom. I can do all that. Whatever I say, suck it, dude. I'm going to say whatever I say.
There are situations, as presented to me through trial recordings and press coverage and personal interviews, that I will be relaying what I feel like the intent was. But again, that's not my intent. And there may be times where, using that narrative storytelling, I will focus on emotions to drive the narrative, and just remember that emotions are not evidence. Emotions are largely interpretive and highly subjective.
I'm very emotional. I can attest to that.
All right. I'm sorry to take so much time on disclaimers. I just felt it was really important. I don't want to offend the victims. I don't want to get sued. I don't want to misrepresent any aspect of the case. And so it's important to bring all these things to your attention so you just understand the complexities and why this case is a bit of a spider web.
So you could take all that disclaimer and put it in your overhead compartment and let's go.
Let's go.
Work. Let's go have fun.
All right. Off to the fun stuff. We're gonna start this with an account of what a neighbor did and saw on the morning of a fire at Marty Fleming's residence. Now, this account of the neighbor's actions is from a press report. The neighbor did not testify in court, although some of the neighbor's actions can be seen on video recordings from the Fleming's security footage. That backs up that this account is likely true. The account of Marty Fleming's actions and the findings from the investigation come from court recordings. So like I said, I'm doing my best to relay the information as it was presented fairly and accurately. I just want to call out when it comes from press and when it comes from court. In May 2011, a man residing on 12th Street in Laurel, Maryland in Prince George's County heard some sort of commotion outside sometime just before 1:45 a.m. Now he looked out his open window and observed a subject wearing a hooded sweatshirt with the hood pulled up and cinched tight. He was doing something in his neighbor, Marty Fleming's driveway. Now, this man assumed that this person was trying to break into one of the two vehicles that was parked in the driveway, so he gathered up his cojones of steel and rushed outside to confront this would-be thief. However, the subject was not, in fact, breaking into vehicles. He was actually attempting to douse the vehicles with gasoline in order to torch them. As this witness with the big cojones exits his house intent on interrupting the presumed car thief, he witnesses something entirely unexpected. As the subject lit both cars in the driveway on fire, he also lit the leg of his pants and one of his shoes on fire.
Nice.
As the witness watched in what had to be horrified curiosity, the subject kicks off his flaming shoe and stomps it out, and then hastily retreats from the scene. Now, the report doesn't actually tell us if he ran off with his pants still aflame or if he was able to extinguish his burning leg before he beat feet out of there in one shoe. It also doesn't tell us what the witness was doing as the subject ran off, but I feel like if I was in that position, I'd be laughing. Now, once our witness shakes off his astonishment and possibly his laughter, he does the neighborly thing and goes to wake Marty Fleming and his wife by banging on their door. Note that not all heroes wear capes. This one was wearing a bathrobe, apparently, and everyone in court got to see him running around in his bathrobe with Fleming attempting to extinguish the two vehicles that at this point are fully engulfed in flames. The two vehicles in question are a personally owned Saturn and a city-issued white Ford Escape. City-issued. Now, Fleming testified in court that sometime between around 1 and 1:30, he was awoken by someone pounding on the front door. So he gets up to go to the door, and as he's approaching the door, he could see through the living room window that there was a glow coming from the area in front of his house. And then he hears his neighbor yelling that his car's on fire. So Fleming grabs 2 fire extinguishers from his kitchen, and kudos to him for having 2 of them so close to each other.
Yeah, that's awesome.
That makes my fire protection heart happy. And he goes outside where he uses these extinguishers to try to keep the flames away from the area where the car's fuel tanks are located, fearing that they would explode. Now, Fleming was successful at keeping the flames from rupturing the fuel tanks, and it wasn't long before the fire department arrives and extinguishes the fire. Now, note that these cars are very close to the house. Mr. Fleming testified that one of the vehicles was only about 4, maybe 4.5 feet from the corner of his house. So had his neighbor not alerted him when he did, it's feasible to presume that the fire could have potentially spread to the house where Marty had been asleep with his wife. Now, as I noted, Fleming did have some security cameras. However, I only got to listen to the tapes of the fire over the court recordings, and nobody was sitting there narrating them for me, which was very sad.
That's how good she is, folks. She can hear a fire and a recording and tell exactly what's happening.
And so it seemed to me, from what I could hear, which was limited, it seemed to me that the cameras captured the neighbor coming to the door, captured Fleming, in which my autocorrect has now changed every instance of Fleming to Flexian, so I'm going to screw that up. It got Fleming exiting the house with the fire extinguishers, and it did capture some of the firefighting efforts. It seemed to me from the discussion in court that it's possible the cameras were not positioned in a manner that allowed us to view the arsonist lighting the fires, but I could be wrong.
And he's a regular homeowner or something, resident. He's not Spielberg out there with his cameras.
No, and when the judge asked him like where this camera was and stuff, he was talking about it being the view of his porch, and the judge asked him what was up in the upper right corner, and he was like, well, there's the driveway. So it seems like maybe a little bit of the driveway was in the upper right corner and the rest of it wasn't. So that's sort of the impression that I got, but I could be wrong because I didn't get to look at this video. If anyone has the video and wants to send it to me, crimetoburn@gmail.com. The fire department arrived and they extinguished the fire. However, they immediately deemed this fire to be suspicious because of the nature of items found in the area immediately around the fire, and probably a little bit from the report of the neighbor that there was a flaming dude running around. I feel like that probably gave it away too, that it was incendiary.
I think there needs to be a superhero meme of a naked man putting out a fire in a bathrobe.
I don't know that he was naked under his bathrobe, I just know that he was wearing a bathrobe.
Well, I was imagining he was naked.
You can imagine whatever you want, whatever makes you happy. I just want to make it clear to the people I'm not asserting that he was naked, because I don't know.
He had redundancy if he was naked.
I'm pretty sure his last name was Johnson, too, so...
Oh, his first name was enormous.
So the fire department, they find some items that they believe necessitates a call to a fire investigator. So investigators arrive, and these are the objects that they find near the fire. They find the remains of one partially burned black Nike Monarch shoe size 10 in the road adjacent to the house. It's likely that this would be the same shoe the witness reports the suspect accidentally set ablaze and stomped out in the road. They also find a Bic lighter, and they found a stick that had char on it.
Why do I find the image in my mind of someone stomping out a shoe that's on fire kind of funny?
The whole image to me was funny.
That should be a meme too, stomping out your shoe. Now you're stocking footed stomping out your shoe that's on fire.
While your pants burn.
What are you going to do with the shoe when you get it put out? You going to put it back on your foot?
I don't know. And then there's like a liar, liar, pants on fire kind of meme just asking to happen there.
No kidding. He obviously didn't put the shoe back on, right?
No, he left it in the street.
Why bother putting it out?
I don't know. All right. Now note, this next little bit, this was not in evidence presented at trial. It did appear in the press. I don't have all the pretrial motions, so my best guess is that this bit of evidence was excluded for some sort of legal reasons, so take this information with a grain of salt. A forensic analysis of the shoe at the lab would identify some sort of fibers that were deemed to be consistent with animal hair inside the shoe.
I bet I have dog hair and cat hair in my shoes.
Yes, and note that Mr. Crawford did have a German Shepherd dog.
Noted.
It was also reported in the press that this stick that they found had cloth wrapped around it like it was a makeshift torch. But in the court testimony, we're told that they did collect gauze from the scene, but it's not indicated that the gauze was wrapped around the stick, and the stick was only said to have char on it. So it's probable that they presumed that the person used gauze and a stick, but the actual gauze used probably burned away in using the stick as a torch. That's what I think they're trying to imply.
All of a sudden, this whole story just took on a Scooby-Doo mystery-esque kind of appeal to it.
Yes.
I would have gotten away with it too.
If I hadn't set my pants on fire. The press also indicated that a black hat was collected from the scene, but this was not presented in court. And I tell you this because I feel like the collection of a black hat at the scene would be a really high-value potential piece of evidence. So I have my doubts that there was a black hat recovered because I think that would have appeared in court. And this is the same news article that talked about the shoe and the fibers in the shoe. So I just want to present that. There's definitely something in that article that I find questionable so that you can make your own determination about what you want about the shoe and the fibers in the shoe. Back to court. This is what the investigator that arrived testified to. Now recall, this was in 2011, so doorbell cameras weren't as prevalent as they are today. However, investigators did want to see if there was any houses beside Marty Fleming's that had cameras. And so as the investigator is walking down the street, he comes to an area where there is a storm drain about 100 yards away from the fire. And in the area of the storm drain, the investigator said that he noted the very strong smell of gasoline and a smell like something was burning. So probably to his intense displeasure, there was an access manhole right adjacent to the storm drain, and like I said, this was about 100 yards from where the fire was, so the investigator calls over the fire department to come and assist him in removing the manhole cover. And when he was questioned about who went down in the manhole, you can sort of hear him sigh and explain that, well, his partner was really more of a robustly built individual, so he had to be the one to go down in the manhole, and it seems like this was not something that he particularly enjoyed doing. I can only suspect that he also read Stephen King's It, because I too don't want to go in any storm drains. When the manhole was opened, they found something fascinating. They found a mostly burned up pair of blue jeans. The investigator photographed the material and collected samples as well as he could, but the jeans had been badly burned, and he indicated that most of it at this point was just ash. However, there were those little rivets, like the little metal connectors that reinforce seams of denim clothing, and so that told the investigator that while the bit of remaining material was badly burned and it did appear to be denim, and the rivets apparently confirmed to him that it had likely been a pair of blue jeans. And since we know the arsonist ran away with his pants alight, we can maybe presume that he may have dropped a trowel right in the middle of the street and tossed them into a storm drain, and we just have to pray that he was wearing his skivvies, because if not, that could have been a really weird drive home. Imagine getting pulled over for speeding or for your car breaking down and having to explain that to the police or AAA.
You think he got burned?
Oh, we're going to discuss that later.
Because that would be pretty compelling.
Yeah. Now, a small sidebar here. Many people think that when they hear about an arsonist catching their clothes on fire, that they, after using a flammable liquid, it's because they splashed flammable liquid onto their clothes. But I'm here to tell you that you don't have to splash flammable liquid onto your clothes for this to happen. Mm. When flammable liquid burns, it's not actually the liquid that's burning. It's the vapors that off-gas from the liquid. So what makes flammable liquids so volatile is that they off-gas at ambient temperatures and pressures. So in order for a liquid fuel to ignite, a competent igniter has to be exposed to the flammable vapors coming off of that liquid within a specific concentration in air to support the flame. So once the fire starts, the heat from that fire can actually cause the liquid to heat and vaporize faster, and it becomes this faster and faster and faster reaction. That's why we call it accelerant. So when you're working with flammable liquid, you don't have to spill it on your clothes. You only have to be close enough for your clothes to absorb the vapors that are off-gassing from the surface of that fuel. So keep that in mind next time you're at a gas pump or you're considering using gasoline to light a bonfire. Your clothes can and will absorb flammable vapors. Last week I posted a video on our Instagram from police in Canada of an arsonist lighting themselves on fire, and I explained this phenomenon. I can't guarantee that our arsonist in this case or in the Canadian video didn't spill liquid onto their pants, but it seems that even a dumb arsonist would know better than to light a match if his clothes were wet with splashed flammable liquids. However, for those of you that can't put this together in your head, don't light a match if any article of your clothing that you're wearing has been splashed with flammable liquids, and keep in mind clothing absorbs vapors. And for you ladies, acetone is a flammable liquid. And now that so many people use 100% acetone instead of the watered down stuff to take off all those fake nails and gel polishes and stuff, do not be doing your nails with your candles lit. If you want a spa experience, this is the time to use those little battery-powered fake candles, because one spill or leaving the top open too long and you're asking for trouble. Guarantee no manicure is worth lifelong scars of a flammable liquid fire, so just wait until you're all done with the volatiles and the room has adequately aired out before you go lighting your candles, your bongs, your cigarettes, your gas stoves, I don't care.
Looking like Freddy Krueger has never been in vogue.
No, it hasn't. So that's the end of my PSA. Alright. Now this information comes from the arrest warrant, but I do not think this video was presented in court. I could be wrong. But this is for several reasons. This could be for several reasons. Perhaps they weren't able to establish the time and date the footage was taken, or maybe the chain of custody was broken. I can only surmise. But for whatever reason, it doesn't appear this video was shown in court. A neighbor down the street provided investigators with footage from their security camera, and police observed a silver four-door sedan drive by the house out of the camera's view shortly before the fire. Then the subject in the hooded sweatshirt is seen entering the frame from the direction that the silver sedan had gone toward. He appeared to stage some items in front of another house down the street. And the video does not catch the subject actually pouring the accelerant on the two vehicles, nor does it show the subject lighting his own pants on fire, which is honestly just a shame. Investigators were equally dismayed to find that they had no good video of the subject's face because he pulled the drawstring on the hooded sweatshirt pretty tight around his face.
It was Kenny from South Park.
It was Kenny. So let's talk a little bit about who was Marty Fleming. Now, Marty was the deputy city administrator for the city of Laurel, so that explains the county vehicle in the car. The county vehicle in the driveway. Now, Laurel isn't all contained in a single county. Laurel is actually in several jurisdictions. The, quote, city limits are fully within PG County, but the outlying parts of Laurel cover Anne Arundel County, Montgomery County, and Howard County. So we have 4 different counties that the city of Laurel is in. Now we know that this arsonist is accused of or tied to fires over 7 different counties, so this creates a jurisdictional nightmare. If an arsonist sets several fires within the same jurisdiction with the same MO, then it's likely that police are going to see that connection and put it together faster. But working over 7 different counties, or 6 different counties, I think I said 7. I've confirmed 6, there may be a 7th. I'm still working on it. Definitely 6 counties. Even if the motives are similar, it just makes it a lot harder to see those patterns because these police departments aren't frequently interfacing and comparing notes. And this was just a property damage crime. No one was injured, no one was killed, and the home wasn't significantly damaged. So I'd like to think that if there had been a more significant injury or property damage, that the police may have reached out to other neighboring jurisdictions a little faster, but I can't guarantee that. Who was Marty Fleming? Now, Marty began working for the city of Laurel in 1976 as a laborer, and he worked his way up through multiple government positions in public works, parks and rec, and even homeland security before he began working as the city's deputy administrator. Now, he met David Crawford at a breakfast meeting. In attendance at this meeting was the city mayor, the chief of police, Fleming, and Crawford. And this meeting was because the city needed a new deputy chief of police, and Crawford had applied for the position. And so this meeting was to discuss that potential employment opportunity. In court, Fleming testified when asked about his initial impressions of David Crawford. He said he didn't feel that Crawford was a good fit for the city, and he actually said that he was kind of concerned. Now, he doesn't elaborate on this feeling of concern because Fleming's feelings toward Crawford are not material, but it does suggest possibly some reasons why the two men may have not been on the best of terms, which might lead to, some possible friction in their relationship. Now, after meeting Crawford, Fleming made it known to the mayor that he was recommending Richard McLaughlin for the role of deputy police chief instead of Crawford. However, the city did hire Crawford as the deputy police chief, and later on, the police chief retired and Crawford was named the acting police chief. And then the mayor and the city council made it official and approved Crawford and made him the chief of police for the city of Laurel. It appears that Fleming had always recommended McLaughlin take the roles that Crawford had been hired to take and promoted into. And it seemed to suggest that Fleming just didn't like Crawford, or that there was some sort of tension there. Or maybe he just had a feeling of loyalty toward Richard McLaughlin. I can't say.
He's true to the dick.
Oh my. I can't say for sure how Fleming felt about Crawford, other than that we know for sure that he recommended somebody else for the job that Crawford wanted. Now, Fleming offered no recounting of any instances of arguments or disagreements with Crawford, and he also indicated that the only people that he had made his recommendations to hire McLaughlin over Crawford to were the mayor, and he had told McLaughlin himself. But he had not publicly disapproved of the appointment of Crawford, and he said that he couldn't have known if anyone filled Crawford in on this information. We know that Crawford is tied to this case, but at the time, police were baffled and they had no leads. All they know is that Marty Fleming is the victim and he is a City of Laurel employee, He was Laurel's deputy city administrator, and it seems from court testimony that he, at this point, had no idea who would have had a grudge against him or why. However, Crawford had just retired from the city of Laurel when this fire happened. According to an interview I had with somebody familiar with the situation, Crawford had been told that he was going to be let go from his position as police chief, and this person told me that Crawford then asked for the opportunity to resign, which he was given. Now, right around this time that he left and resigned, presumably against his will, someone fired a bullet through the window of the home of Christy Mills. And Christy Mills was Laurel's city administrator, and she happened to be Marty Fleming's boss. Now, Crawford has never been accused, to my knowledge, of being tied to that bullet through the window, or I've never heard any discussion, aside from one newspaper article, that indicated that there was some tension between them, and one person that used to work with them suggested that they thought that it should be looked into whether or not Crawford may be responsible. But that's not my opinion. I'm just putting it out there that it was in the press. Somebody said that Crawford may have had some beef with the city administrator's office.
Why you got a beef again?
Crawford may have had some pork with the... I'm just kidding. Crawford may have had some friction with the city administrator's office. Is friction worse? What's happening?
No, I don't know. I don't know. I have a hang up with you saying beef.
Okay.
I don't know why. It sounds fine. You should say beef all you want. Beef.
Now, when Crawford did retire, the person who took his place as the chief of police was none other than Richard McLaughlin, the person that Fleming had initially recommended for the position of police chief and the person that was then promoted after Crawford left. But why had the city decided to relieve Crawford of duty before he resigned? According to my source, he'd initially been a great police chief. He had been keeping the city council updated on all of the issues of importance. He had been following all of the protocols and doing all of the things requested of him. But the longer he was in the position, the more lax he started to become in keeping up with providing information that was requested of him by the city council. At this point, all we know is that Fleming has no idea who might have had some tuna with him. Fleming has no idea who might have wanted to harm him. Unfortunately, this means that all police know is they're looking for a one-shoed sedan-driving, pantsless man smelling of singed leg hair, wearing a hoodie, and having enough disposable income to afford extra gasoline that isn't going into his vehicle, but not enough smarts to realize that gasoline vapors can permeate fabric. So with little to go on...
That could be anybody.
Police, exactly. With little to go on, police actually place an ad in a local paper offering a $5,000 reward for any information related to the fire at Mr. Marty Fleming's house. Despite the offer of a reward, the case goes cold. For a decade.
Whoa.
But Mr. Crawford would not be sitting by idly during that decade enjoying his retirement and playing golf. He would be a very busy man. And we're going to cover more of exactly what he was allegedly up to during that time on part 2 of the David Michael Crawford case on Crime to Burn.
This is very interesting.
What if I tell you that next week we're going to be talking about a fire that occurred at a home owned by none other than Mr. Richard McLaughlin?
I would tell you I don't know who that is.
He's the guy that Marty Fleming recommended for the position of police chief over David Crawford.
Oh.
And he's the guy that was promoted to police chief after Crawford retired.
You know what? I bought a whiteboard.
We're going to probably need it for this.
I'm going to bring that down.
Okay.
I'm gonna need it. I'm already getting to my capacity of things I can keep in my consciousness.
So to summarize this week, number 1, don't sue me. Number 2,
or me, even though I'm gonna say whatever I want.
Number 2, Marty Fleming was the deputy city administrator that worked alongside David Crawford when he was police chief of Laurel. And number 3, somebody set fire to Marty's vehicles, including his city-owned vehicle, and set themselves on fire in the process. And number 4, police have no idea who could be responsible.
And number whatever, Stomping out your flaming shoe and leaving it on the scene is hilarious.
It is. Well, and the thing is that, okay, so they reportedly found trace evidence inside the shoe. If he had not stomped it out and had just taken it off and left it there, that trace evidence probably would have burned.
This is going to be fun. This guy's obviously a really demented goofball.
That's your opinion, man.
It is, and I'm sticking to it so far. My opinions may change as we go along. I don't have enough information to really have an opinion yet. But they're going to change. They're going to be fluid. They're going to be opinion fluid.
And that's the intention. I'm going to be the unbiased person. I'm going to be the person that just tries to look at the evidence and look at the stuff and talk to the people, and then you can be the opinions.
Yeah.
I'm not going to say that my opinion's never going to shine through, but that was why I made that whole disclaimer about my own personal bias.
I'm not going to say my opinions will shine at all, but they'll be mine.
So yeah, I have been working on this case since February, and it's August.
It's still going on.
It's still going on. I'm not done.
It's not. This is actually like relevant right now news kind of stuff.
It is. All right. The appellate brief, I think, was filed. It was either July 6th or July 16th. And there was also an extension filed for something. I don't know what. And there was a couple stipulations filed. Do you know what a stipulation is in court? Because I just recently learned this.
Yeah, that's where you look up at the ceiling and it's got like those hanging down looking textures.
No, that's not a stipulation. It's a ceiling texture.
What's it called?
I don't know.
Oh, and now you're the expert that doesn't know
ceiling
something.
Stippling.
Ah, you do.
So, a stipulation in court is, let's say that we have a witness that would testify, hey, I lived at that house next to this house that caught fire, right, at this time. And I submit, and here's my security tape that I gave to the police. But the witness, for whatever reason, can't show up to court or can't be there. Then if the defense and the prosecution agree on what the witness would say, they will draft a statement that they both sort of approve, and they will present it to the jury as fact that both sides agree on. That is a stipulation.
Oh, sounds complicated.
Yeah, but I didn't know what it was until this case, because as we know, my jury service was cut short by a death penalty joke, so I didn't have a lot of opportunity to observe the judicial system in motion. Sorry, Judge Russell.
I imagine I'll probably have to do jury duty someday. I was called up for it, but I didn't have to go because I had a little kid.
Yeah. Oh yeah, that's right. You're a primary caregiver. I imagine that I probably, like, if it was like a day of traffic court or something, they probably wouldn't eliminate me, but I imagine that most criminal courts would eliminate me because I have a true crime podcast and I spend a lot of time.
Well, I hope they don't eliminate me. That sounds like fun. I hope they have free coffee.
I can tell you exactly what you need to say to not get eliminated.
Oh, yeah?
Yeah.
That could be our PSA. If you don't want to be eliminated from traffic court.
Well, not from traffic court, from criminal court.
If you don't want to be eliminated from jury duty?
Yeah.
Yeah, what?
You need to tell them that the defendant is always innocent until proven guilty. It is the state's responsibility to prove guilt, and that they can only base their decisions on things that are presented in the courtroom, not on anything that they may know, not just about the case, but about subjects related to the case. So, like, if I probably would not be allowed to serve on an arson jury because I know a lot about fire, and I would not be able to discharge all of my knowledge and only accept what the expert witness was telling me in court, because if they were lying and I knew it, I wouldn't be able to keep my mouth shut.
Yeah, but the way I heard whatever it is that you just said sounded like that's a good way to have a jury.
That they can't have knowledge of any of the...
All those 3 stipulations that you gave, is that a stipulation?
No.
No, I just used that word out of context, didn't I?
Yeah.
What should I use?
There would be 3 traits that would make up an ideal juror to the court.
That should be an ideal juror to everyone.
Yeah.
That's the way.
That is the way. But there's definitely people that walk into court. Part of the court recordings that I have are the voir dire process. All of the questions that they posed to jury members about their experience and, you know, any little area that could have impacted the trial. So.
Oh, I thought that was just a different way to cook raw beef.
Voir dire?
Yeah.
No.
It sounded French.
In this case, remember when we talked about the Benson case and I explained that the voir dire process of questioning each individual juror happened in front of all the other jurors?
I didn't know there was going to be a test.
Okay, well, that's what I told you in the Benson case. That was one of my issues. Because basically they were telling the jurors exactly what they needed to hear from them in order to get put on the jury. And this was a really big case and people wanted on this jury. In this case, they did it right. Each juror was questioned up at the bench with the white noise on so that it was only picked up by the microphones and you could only hear it in the immediate vicinity.
Oh, I didn't know that they played white noise to keep people from hearing that.
They play white noise to keep you from hearing the bench conferences and the voir dire questioning. At least in Howard County. Different counties may do things differently, but this was the trial that where he was found guilty and convicted was in Howard County, Maryland.
Sounds fancy.
Howard County sounds fancy?
No.
Oh, the white noise
They
thing?
got the white noise technology.
Well, I will say that they had some very big technology challenges through this trial.
Oh, yeah?
Because they publish the evidence on screens. They have screens that the jury can see. They have screens at the defense and prosecution tables. They have a screen, obviously, for the court reporter. They have screens that the audience can see and that the judge can see. So when they proffer a piece of evidence, they first admit it, they mark it for identification, and then it gets published to the lawyers and the judge and the clerk and the witness. And they ask the witness, like, is this an email you sent? And the witness would say, yeah, that's an email I sent. And then they would say, all right, now that we've identified that that's what it is, now I move it into evidence. And then the other attorney has the opportunity to object to it going into evidence or to accept it. And if it goes into evidence, then it gets published to all the screens when they talk about it in court. So it's identification first, move to evidence, then published to everybody. And the screens in the jury box at the beginning of the trial kept going out.
It's like when you take a really fun game and add way too many rules to it. It becomes not fun anymore.
Yeah.
Well, neat. This is my last beer, and then you got to go on a beer run.
I don't want to go to the pool because I'm still peeling. Everyone will look at me and be like, excuse me, your skin's coming off in the pool?
She really enjoyed it the last time we took her on a brewery tour. Those people in there were so cool too, man. They set her up in front of a movie.
They did.
They put a movie on.
They gave her like crayons.
Yeah.
And she's still, that was more than a year ago, and she's still, every time we talk about it, or every time anything comes up, she's like, what are you going to do? Make me go to a brewery again? We've taken her to one brewery in her life.
No, we traumatize her so much. She's going to pay a counselor to listen about that someday, maybe.
About going on one brewery tour?
Yeah, because you do something that's that horrible once. You always do it now. That's your MO now.
That's my identity.
Gotta strike that from the record. We haven't taken her on a winery tour. And, you know, when we buy her a car or something like that, we're going to have to be really explicit when we explain to her that this is paying that back and now it's over.
Now it's over. Toyota erases all sins.
Oh, you're going fancy. Do I look like I play with Legos?
We bought her a four-wheeler. Can't we start erasing some of the stuff with a four-wheeler? I was admittedly a spoiled child. The one with the rotating things.
What is happening?
The dog wants in.
I have an assortment of freezer pizzas for lunch if you're interested.
So I'm still full of waffles.
Well, now I know it's a man. Well,
you know who it was.
A mailman. Mailman. It wasn't
it was a mailman.
It was a postal worker.
It's that fan.
I know.
It's wobbly wobbly.
Yeah.
Pause for wobbly fan rectification. Pull the cord, baby. Let's make it hot in here and turn off all our fans. It will get so hot you'll want to take your clothes off.
What are the elephants doing?
I don't know.
Well, I didn't say you were doing it. I was blaming your elephant. I did not fart. Sometimes you come up with good ideas when you're listening to stuff. How come no one makes a waffle bun for a hot dog?
Who's your agent?
You know, Chad's my agent.
Chad can't talk. Chad is a mannequin. So once upon a time, every time I asked my husband if he needed anything while he was out, he would tell me he needs a mannequin. And every time I asked him what for, he wouldn't answer me. And so my parents were coming to our house for Christmas, and I thought there would be nothing funnier than watching my husband open a mannequin and pull body parts out of a box in front of my parents on Christmas morning. So I bought him a mannequin, and it was just as funny as I had hoped. It was fantastic. Anyway, so Chad lives in our bar now. He's Chad the Barefoot Barback. He has a great poker face, but he's a really good listener. He doesn't think I'm funny, though. He never laughs at my jokes.
I wrote down waffle dogs, right?
Waffle dogs.